అందరికీ శుభోదయం. గుడ్ మార్నింగ్ టు ఆల్ ఆఫ్ యూ. వెల్కమ్ టు లీగల్ మ్యాటర్స్ బై సాయిబాబా సుంకర. సిపిసి క్లాస్ జడ్జ్మెంట్ ఆన్ అటాచ్మెంట్ బిఫోర్ జడ్జ్మెంట్. Attachment before judgment. Very good case law. Normally, while dealing with Order 38, I told you regarding arrest before judgment and attachment before judgment. The procedure for arrest is envisaged in section 55 to almost 58. And in this connection, remember that a woman in money related suit cannot be arrested. Money related suit. కోటి రూపాయలు సరే woman arrest చేయడానికి లేదు. Right. When there is a fraudulent sale, definitely attachment before judgment is valid, is justified. Supreme Court judgment. In the case of LK Prabhu alias L.K.Prabhu deceased through LRs versus K.T.Mathew alias Thampan Thomas and others on 26th November 2025. Honorable Supreme Court of India, two judges bench, held that the property sale made by the defendant K.T.Mathew to LK Prabhu was fraudulent because it was done only to avoid payment to the payment which is pending in the so-and-so pending case. Right. Here, actually, this K.T.Mathew, who is the bidder or who is the purchaser, he filed a petition for the so-called under Order 38, Rule 5. That is for the attachment before judgment. Before this, we all know when attachment has to be made. What is attachment? Attachment is nothing but seizure of some property, seizure of movable or immovable property, and in anticipation of a favorable order. This is attachment. Sometimes it may rebuff also. If it is rebuffed, then Section 144 of the CPC comes into existence. Doctrine of restitution. Restitution, you have to give back the property to the concerned party. Here, two incidents happened. One is the purchase was made before the judgment. For that, it's okay. But after the decree is drawn, before the execution, some part of the property, one of the defendants, he sold it to the so-called LK Prabhu. LK Prabhu, he has purchased the property and he wanted to get it from the so-called party, but the complainant in the original suit, that is K.T.Mathew, he has filed a petition under Order 38, Rule 5 for the attachment before judgment. Because even the decree is not, that's I think some preliminary decree was given, that's also decree. So, and once the decree is drawn, you are not supposed to transfer. Section 64 of the CPC, please read it. You cannot transfer, you cannot align it, you cannot sell the property to anybody. And this was done. After the decree was drawn, the property was purchased. And remember, the buyer, Mr. Prabhu, knew all about the case and still helped in the fraud. Therefore, even though he came from public to the Supreme Court, he cannot get any protection. So, previously, what he purchased before the judgment, it's okay. We are not bothered. That was okay. But after the judgment is delivered and the decree is drawn, if you are purchasing, you are helping from another defendant by purchasing the property, not at all allowed. Because of this, the attachment before judgment has been ordered by the trial court. It's valid. Because some cases have to be, it's only preliminary decree. It has to be judgment. So, we don't know. Judgment may be reversed also. When he goes for appeal, judgment may be reversed also. So, therefore, even the trial court, high court did not accept, Supreme Court also did not accept this decree. So, in this, what you have to learn is attachment before judgment can be done in only important cases. If any property is purchased before the judgment, we cannot do anything. That is the crux of the judgment. Please read the case law and enrich your legal law. Thank you.